Iku Iluna, please rise. Ea ke aha o kolo kolo ki I ke hano hano u a ko koa hou maila. This Honorable Supreme Court is now reconvened. Inoho Ilalo, please be seated.
All right, please call the case.
Case number SCWC-22-0000516, Sierra Club Petitioner Appellant Appellee versus Board of Land and Natural Resources, Respondent Appellee Cross Appellee, County of Maui Respondent Appellee Cross Appellant, and Alexander and Baldwin Incorporated and East Maui Irrigation Company, LLC, Respondents Appellants Cross Appellees. Arguing for Petitioner, Sierra Club, David Frankel. Arguing for Respondent, Board of Land and Natural Resources, Melissa Goldman. Arguing for Respondents, Alexander and Baldwin Incorporated and East Maui Irrigation Company, Trisha Akagi. Also appearing, Christopher Gooden. Also appearing, Mariana Lawi Gerstmar, County of Maui. Argument on the merits.
All right, good afternoon, aloha everyone. Our proceeding today is being broadcast live on the Judiciary's YouTube channel as well as on Olelo. I'd like to welcome our substitute justice, Judge Clarissa Malinao. Thank you, Judge Malinao, for joining us. Counselor, are you all ready to proceed? All right. We have 30 minutes for each side for our argument. Mr. Frankel, we're going to give you a warning light 20 minutes into your argument so that you know you're starting to get into your rebuttal time. Ms. Goldman, 17 minutes. We're going to give you a 2-minute warning, and Ms. Akagi, 13 minutes with a 2-minute warning. Sound about right? All right, let's proceed. Thank you so much.
Aloha, Chief Justice Reckton-Wald and members of the court. The O'opu Alamo'o can climb waterfalls hundreds of feet high, but it can't climb them if there's no water in the stream. In its answer to paragraph 45 of the statement of the case in this appeal, the Board of Land and Natural Resources says that it is without knowledge or information to form a belief as to whether stream diversions cause significant harm to native stream life. Well, a contested case hearing would have allowed the board to ascertain this and other basic facts before allowing A&B to take all the base flow from a dozen streams, draining them dry. When the board allowed A&B to take all the base flow, without having to face cross-examination from the Sierra Club, it violated the Sierra Club's due process rights. In its published opinion, the ICA overlooked the plain language of HRS Chapter 205A, new evidence that emerged after trial, the significance of this new evidence as characterized by Judge Crabtree, who oversaw the 2-week trial, and it also overlooked the high level of procedural fairness provided by a contested case hearing, cross-examination, testimony taken under oath, a neutral decision maker, a factual record developed through a rigorous adversarial process, and placing the burden of proof on the applicant. The ICA discounted the value of these procedural protections emphasized by this court in Mauna Kea and treated the Carmichael decision as an advisory opinion. Today, I want to focus on 3 issues. First, HRS Chapter 205A limited the scope of the board's authority. Second, constitutional due process required a contested case hearing. And third, the Environmental Court properly exercised its authority in modifying the board's decision. So first, in acting within the scope of 171-55, the board was obligated to comply with the Coastal Zone Management Act. Sections 205A 2, 4, and 5 limit the scope of BLNR's authority. Chapter 205 applies to all lands in the state. It applies to state boards, including BLNR. It explicitly requires that BLNR give full consideration to ecological values, and it requires that BLNR enforce the objectives and policies of the chapter. BLNR was required to consider the impact of the diversions of millions of gallons of water a day from streams that would normally flow to the sea. The ICA ignored the plain language of the Coastal Zone Management Act and gutted it. Given BLNR's duties pursuant to Chapter 205A, a contested case hearing was required, which is the second issue I want to address. The Sierra Club's constitutional right to a healthy environment includes the right to full consideration of ecological values, protection of coastal resources, including streams, an overall conservation ethic, and effective regulation of stream diversions that minimizes disruption of coastal water ecosystems. These are all found in HRS Chapter 25A. In addition, the constitutional right also includes consideration of the state's best interest, which includes protection of streams. Moreover, the public must have a means to ensure that constitutionally protected public trust resources are properly managed.
Council, can I ask you, up to this point when you folks came up on that hearing in November of 2020, those permits have been rolled over for about 20 years, is that about right?
Correct.
How many contested case hearings were had on any one of those rollovers?
At that point, none on the revocable permit. The Board of Land and Natural Resources had granted Namoku's request back in 2001 to have a contested case hearing on the revocable permits, but it was never held. So no, there had been none.
Thank you.
You know, on that, I mean, did they ever, when it was never held, I mean, what was the reason? I mean, was it just punted? Did they advocate for the hearing? I mean, what happened?
As far as Namoku was
Yes.
concerned, Namoku spent a decade in frustration attempting to get the contested case here, and this is not on the record, but they attempted to get the hearing started. There were motions filed with the BLNR. There were cases filed in circuit court. But yeah, the contested case hearing on the RPs was never held.
Okay, you know, and they're making the point that, look, you just had a trial.
Yeah.
2 months beforehand, you come in, Sierra Club, you're obviously on your game, you're submitting written testimony. You actually argued for about 18 minutes, they say, and I imagine it was probably pretty effective. You know, I mean, what more process do you want other than cross-examination? And granted, you probably have skillful cross-examination skills too, but I'm just wondering, I mean, how's the claim deprivation alleviated by more stuff?
Sure. First of all, I want to emphasize a contested case hearing enables the Board of Land Natural Resources to ascertain the truth of the matter. They don't know the truth, as demonstrated in their statement, their answer to the statement of the case. But furthermore, there's new evidence that came up since trial. In October 2020, which is after the trial and a month before the board met, the Division of Aquatic Resources went on a site visit to visit the streams that had been ignored for a long time. And they found value in these streams. For example, at Nailiili Haele, they found Oopu and Opai, and the division concluded that it had high potential for habitat and it was a high priority for restoration. So this is the kind of new evidence that was available that was not available during the trial. We also know that—
But that new evidence the board did take a look at that new evidence, didn't they? You're just going back to your cross-examination.
That's true. And it would, so in their briefs, the Board of Land and Natural Resources has suggested that even though it was a high priority for restoration, it really wasn't a high priority. It was evaluating streams, just these 12 streams compared to each other. We disagree with that conclusion, but given that, we should have had the opportunity to ask, not even in a harsh cross-examination way, but ask Aquatic Resources what they saw as the value. Was there value in restoring these streams to flow? That's the kind of thing that, with evidence taken under oath, with all parties cross-examining or asking questions, the truth can come out. It is, another piece of evidence was that Alexander and Baldwin submitted a report for the third quarter of the year, which showed that they needed less water than they claimed, yet they wanted more water in 2021.
You know, at Mauna Kea, we pointed out the value of a contested case hearing. I don't think anyone's disputing that, but, you know, what evidence were you not able to present that you claim was new, that for whatever reason you weren't able to present it at this public hearing at that point in time?
So while the Sierra Club has sued a lot, it does not have aquatic biologists or hydrologists on staff. The information really is retained by the Department of Land and Natural Resources and Alexander and Baldwin. We need to call them as witnesses on the stand to answer questions. For example, how—
And you know what was unclear to me, and I apologize for interrupting, but when did you folks get those staff reports? I wasn't real clear on the timing.
generally staff reports are available 5-6 days before the board meets. I can't say, I mean, that's the general practice. I'm pretty confident that's what happened here, but I can't swear that that's exactly when we got the report, but it wouldn't have been more than a week ahead of time.
Well, you wouldn't have had an opportunity to get experts lined up to
No.
bring at the hearing, would you?
No, we had an expert from our trial, and actually, I don't think it's not in the record, but yeah, we can't, when you testify before the Board of Land and Natural Resources, the time period is relatively limited, in which people—
Well, the agenda said 3 minutes max. I know you folks had 18, but for everyone else, was it kept on a 3-minute clock?
I believe so, but I can't swear to that. I don't, and the record's incomplete. We have I don't even know if we really have the minutes of that meeting, but it is true that the amount of, first of all, none of the testimony is taken under oath. And there is a limit to how long people can speak.
It's like a public hearing, right?
Correct.
It's not a adversarial proceeding in which evidence is developed, objections are made and the like, correct?
Exactly, exactly.
Can I take you back to the Coastal Zone Management Act? So the
Sure.
ICA's position was it did not affect BLNR's authority to continue the permit. So I guess they're trying to argue that the issues addressed by the Coastal Zone Management Act in the context of these mountain streams, I guess they would say, was tangential to the issues and therefore didn't give rise to a right to a hearing. What's your response to that?
So how do I start? 205A applies to all lands in the state. That's the plain language, and that's what the legislature made clear in 1993, and it applies to the board. What the ICA has said is that essentially only Part 3 of the Coastal Zone Management Act is applicable. In other words, when things are very near the shoreline, the special management area or the shoreline setback area. But that's not what HRS 205A says. In 205A-2A says, the objectives and policies in this chapter shall apply to all parts, not just Part 3, which is for the special management area, but also Part 1. And the language in 205A-4 and -5 are quite clear. They are binding on agencies. And the legislature made that clear too when it enacted 205A. It's in the legislative history and clear with the purpose. So basically, the plain language, the legislative history, and the intent all align that, yeah, the board was responsible. And if I can point out, in ICA memorandum opinion, Kila Kila Ohalekala versus BLNR, this is 134 Hawaii 132. It's only a memorandum opinion, but in that opinion, the ICA acknowledged the board at that time recognized that its action approving a telescope on the top of Haleakala had to be consistent with the goals and objectives of HRS Chapter 205A. So that was BLNR's position a decade ago, and for some reason now it no longer believes it has to comply with that law.
Counsel, may I inquire, is there an apparent conflict and competing intent by the legislature within 205A 171-55 and 171-58, and how do you resolve that conflict?
I guess I don't see a conflict. For example, what are the best interests of the state? Well, the best interests have been articulated in HRS Chapter 205A. And so those two are clearly consistent with each other. 58 doesn't apply here, but the similar principles are articulated there. It doesn't, under Carmichael, 58 is not applicable for when continuing the revocable permit. But yeah, they're all clearly consistent with each other.
Well, you know that part 1 of 205A, there's 5 sections and they all seem to have their own definitions under 205A. And the provision you're just referring to comes under part 1.
Correct.
That applies to all agencies, all state lands, and all those objectives and policies are supposed to be enforced or at least recognized by those agencies.
Right.
Would that include BLNR?
Yes, right. All boards of the state are included within the definition of agency, so yes.
Right, so that's sort of like a Malcolm Mackay concept that's incorporated in 205A. Is that your reading on it?
Exactly.
The streams connect Malka to Mackay.
Exactly. Yes, Your Honor. So an additional constitutional right involved here is that these are public trust resources. And how else does the public ensure that trust assets are not squandered? By participating in a contested case hearing, that is the means. The interests are property within the meaning of the Due Process Clause. When constitutional interests are implicated, an agency hearing is required. Well, what kind of hearing? What procedures are required? It's unnecessary to engage in further constitutional analysis because the legislature provided an answer. HRS 91-9 through 13 articulate the procedures that are necessary whenever constitutional interests are implicated. So the 3-part test that we're certainly willing to go there, but it's unnecessary because the legislature has articulated the procedure.
Well, you say it's unnecessary. I mean, and your briefing says, hey, look at the older Supreme Court cases. They don't talk about the 3-factor test. I mean, if I'm getting it correct, and what I think you just said was, constitutional interest alone requires a contested case hearing. Can you further elaborate about
Sure.
that?
When constitutional interests are implicated, their due process concerns naturally arise. I've just mentioned what those interests are in this case. So if you look at Pele Defense Fund versus Puna Geothermal Venture, the court said because these constitutional interests are affected, you have to have a contested case hearing. And this is after the Sandy Beach decision. Bush versus Hawaiian Home Commission says the same thing. Aguiar and Town versus Land Use Commission. All these cases state this. So you don't have to go through the full-blown 3-part test to.
Yeah, but I mean, we've had cases also that says due process is not a fixed concept. It's based on a case-by-case basis. I mean, doesn't that conflict with your notion of constitutional interest, automatic contested case hearing?
No, because what the legislature has set out is the procedure. And if the legislature was silent, as in, for example, Madeiros or Sandy Beach, then you have to go through that test. But you don't have to go through that test if when property interests are implicated. Because when property interests are implicated, you have a right to a hearing. That's what that's what the how much due process? Again, the legislature's answered the question, so you don't have to go there.
But the
Counsel-
ICA is saying, I'm sorry, go ahead.
No, go ahead, Justice
No,
Devins.
you go.
Oh, thank you. I'd like your thoughts on when BLNR acted to redefine water waste as use. Is that a violation of constitutional protection?
It is inconsistent with their public trust obligations, yes. There is a public trust duty to ensure that water goes to public trust purposes. When it's wasted, it's not fulfilling that mandate. When you employ an Orwellian definition, which is what BLNR did, to say all system losses and evaporation are not considered waste, well, then there's nothing else left in the definition of waste. And that is extremely problematic. And this is one of the issues that we hope to explore in the context of a contested case hearing.
Thank
Yeah.
you.
So the erroneous deprivation occurred in this case. BLNR made its decision without findings. It made it without waiting for the completion of an EIS. It didn't even know whether stream diversions caused significant adverse impacts to native stream life. It didn't consider how to minimize the adverse impacts to public trust resources. It was made without scrutiny, in the words of the Carmichael Court.
Is it your position that they were required to issue findings supporting the best interests of the state,
Absolutely, Your Honor, right? And
although it was just a public hearing?
yeah, that's what Carmichael says, yes. And a contested case hearing would have allowed them to make those findings. That's
Right, and all we have is conditions, right? There's no actual findings of fact,
they're not
just conditions.
correct.
Some old, some new.
Correct. So contested case hearing would have allowed the development of a record. It would have helped to ensure that A&B fulfilled its burden. It would have ensured that the BLNR had the knowledge and information it needed to make a sound decision.
So on appeal, when the circuit court looks at it, what findings or what are they supposed to be, what is the court supposed to be deferring to or giving deferential treatment to?
Right, there should not and cannot be deference when an agency doesn't make findings. And it's particularly important in the context of public
What
trust
about to
resources.
the conditions?
A condition is not a finding. I think you need to have findings to justify the conditions,
Thank
right?
you.
Now, so the third point I want to raise today is that the environmental court had the authority to modify the board's decision. And this authority is provided in HRS 9114G, the plain language, and as discussed by this court in Nakamine. The environmental court did not decide whether BLNR's decision was a correct one or not. Rather, it crafted a remedy in light of BLNR's denial of the Sierra Club's constitutional rights. A&B and BLNR cannot complain about the modification. They themselves asked the environmental court to modify BLNR's decision, the expiration dates. They can't now argue that the court lacks the power to modify BLNR's decision when they previously asked the court to modify that decision. Moreover, it was in A&B's interest for the court to modify the BLNR's decision, because if it had not, if the court had invalidated the permits, A&B would not have been entitled to any water whatsoever. It's really hypocritical of them to condemn the court for modifying.
What about the argument that the court's substituting its judgment for that of the BLNR and they should have just remanded, sent it back?
Well, in that case, the constitutional violation would have gone unabated. So A&B would have been allowed to take even more water, and we would have been in the situation that Namoku was in back in 2001, asking for a contested case hearing, not having it, and them taking more and more water. That's the problem. What the court did, which is genius, it preserved the status quo. It didn't use those words, but basically it looked at how much water Mahipono, A&B, EMI had been taking, and said, okay, you can use a little bit more, but no more. We're looking at what your use has been. And it preserved the status quo until a contested case hearing was completed. For decades, BLNR gave A&B as much water as A&B wanted, while shielding it from having to disclose critical information under oath or face cross-examination. If we cannot protect our streams in a contested case hearing, how can we protect these public trust resources? BLNR was required to hold a formal contested case hearing before allowing A&B to take all the base flow from a dozen streams. The environmental court's orders and judgment should be affirmed. Thank you.
All right. Thank you, Mr. Frankel. Next, we'll be hearing from Ms. Goldman.
Can you hear me okay?
So far, so good.
Okay. Good afternoon. May it please the court, Deputy Attorney General Melissa Goldman for the Board of Land and Natural Resources. I'd like to focus on two key points today. First, Sierra Club was not constitutionally entitled to a contested case hearing on the RPs for 2021, which it requested just 2 months after trial during a public meeting it participated in. And second, even if Sierra Club was entitled to a contested case hearing, the environmental court exceeded its appellate jurisdiction by modifying permit terms that were not before it based on an undeveloped record to advance one party's interests over inclusive policies reflecting public input and agency expertise. And before addressing these points, I'd like to correct a few misstatements and provide a little context. The board did not authorize diversions that drain the streams dry, as we have clearly explained in the board's response to the cert petition, docket 28 in footnotes 12 and 13. The 2021 RP conditions require compliance with the Commission on Water Resources Management, or CWRM's 2018 IIFS decision, which restored most of the 36 diverted streams in the watershed. Now, council didn't talk about it just now, but he may on rebuttal. The streams in the pictures that he will show you, they come from a 2009 study in Circuit Court Docket 94, and they both show streams that were restored by the CWRM's 2018 IIFS decision. Interim in-stream flow standards are established under the State Water Code, HRS Chapter 174C, and they dictate the quantity of water that's required to remain flowing at any given time. CWRM has exclusive jurisdiction and final authority in all matters relating to implementation and administration of the State Water Code under 174C-7A. That includes diversion modification issues as well, so that topic is outside the scope of these proceedings. Now, turning to our first point. Under the controlling two-step Flores test, to establish whether due process requires a contested case hearing, Hawaii courts first determine if a constitutional interest exists, but then they turn to a second step in which they evaluate which specific procedures are required to protect it through the Sandy Beach balancing of the private interest affected, the risk of erroneous deprivation through procedures that were used, and the governmental burden of providing those additional procedures. All three factors cut against Sierra Club in this case. Due process, as Justice Edens just recounted, is not a fixed concept requiring specific procedural course in every situation. Under this court's precedent since 1989, courts evaluate claimed property deprivations on a case-by-case basis by balancing multiple factors. So the mere existence of a constitutional interest does not automatically require a contested case hearing. Here, Sierra Club had ample process through a full trial just months earlier on nearly identical issues, a public meeting with notice and an opportunity to be heard by presenting evidence and expressing its views, and it made no showing that additional procedures would be meaningful in the context of this decision. Here, Sierra Club's written petition offered nothing to suggest that it had different concerns or sought to vindicate different interests with respect to the 2021 RPs from those that it had already fully aired at trial. In the Flores case, an applicant sought to protect his constitutional interest to engage in traditional and customary Native Hawaiian practices, a very important interest. Mr. Flores had already participated in a contested case hearing regarding the Conservation District use permit application for construction of a telescope on Mauna Kea. So when he opposed the sublease consent for the construction parcel, alleging interference with the same interest, this court held that no additional process was warranted because he was, quote, already afforded a full and fair opportunity to express his views and concerns as to the effect that the proposed action would
Can I
have.
ask you, counsel, it's one thing to be able to express views, it's another to be cross-examined and to have the adversarial process really get to the truth of the matter. As I understand these public hearings, people come up, they say whatever they want to say, conclusory statements, whatever opinions they may have, but they're never really challenged under cross-examination. Isn't that really the point that Sierra Club's making, that they want to have that opportunity to make it a meaningful opportunity to present their case?
Well, cross-examination of every witness and piece of evidence is not a required component of due process, which requires an opportunity with notice and a meaningful opportunity to be heard. Sierra Club does not show that anything it wanted to ask about would have meaningfully impacted its interests or offer value to the board's decision.
Weren't there new conditions that were imposed with these 2021 permits?
There were new conditions imposed, however,
Were those conditions part of the trial? Or were these brand new conditions?
one of the conditions, for example, that was added was a statement of intent to deal with issues regarding system loss and modification to the diversion
So that was a brand
system
new
as a whole.
condition.
That was a brand new condition.
Okay, and
However,
they didn't really get a chance to challenge that, did they? On whoever, whether it was by the staff, whoever proposed that, they didn't get to really examine the veracity or the credibility or the accuracy of that, did they?
well, that condition was not really a statement of intent. Does not go to an issue of material fact, and courts generally have recognized that cross-examination really only has value when there is a material issue of fact at issue. When the issue is something regarding policy, weighing.
What about the 4 priority streams? Did that come up in the trial?
The entire basis of the trial on the public trust duties of the board had to do with the 12 streams. And
But the 4 being designated as priorities, was that part of the trial? Or was that something brand new?
the prioritization study by DAR was brand new. However, Sierra Club mischaracterizes the study, which did look at the 12 streams relative to one another.
Okay, isn't that kind of their point? The fact that you're fighting over what this means or that means or this evidence, that's why they're saying they needed a contested case hearing on all of this, because you're fighting over what evidence really meant or what the intent was or how accurate it is. Doesn't that really support their argument?
Well, in particular, the DAR prioritization study, for example, I would characterize that as a scientific disagreement going to overall ecosystem health. That is an issue that is squarely within the jurisdiction of the Water Commission.
But by the time they learn of it, they only have like 5-6 days to get an expert, and that's not practical. I mean,
Well-
is that a meaningful opportunity to present your case at a public hearing
Yes, Your Honor, and this court has previously held.
without experts?
Yes, Your Honor. First of all, they did have an expert retained for trial, and they did have a trial expert report that had been excluded for procedural reasons. They could have
Did
easily
they have
offered
an
it.
expert to challenge this 4-priority designation? 5 to 6 days out.
I believe that
I would guess not, but
Well, I believe that the purpose of the expert report was to talk about the value of each of those 12 streams. However, regardless, this court has held that the public meeting process can be sufficient. In Mederos, for example, sunshine procedures offered sufficient due process, even though speaking times were limited and no cross-examination of agency staff was allowed, because the opponents of the proposed action still had an opportunity to voice their concerns at the meeting and to submit evidence beforehand.
and that really goes to whether or not it's meaningful or not. Isn't that what you're driving at?
In part, Your Honor. However, what matters is that there are new material facts that could lead to an erroneous deprivation of protected interests that were not examined through procedures previously used. So, regarding ecosystem concerns, as I said, that matter goes to something under the exclusive jurisdiction of CWRM under the Water Code, while the board's role under 17155 is limited to land. All permits are subject to the CWRM's IIFS requirements, but the board lacks authority to directly regulate streams, and this jurisdictional divide is important. In fact, Sierra Club successfully petitioned the CWRM to amend the IIFS for those 12 streams in 2022, demonstrating that the avenue was both available to it and effective. Under the administrative rules, HAR 13-1-29.1, the board can deny a contested case hearing request when, quote, it is clear as a matter of law that the request concerns subject matter that is not within the adjudicatory jurisdiction of the board.
What about system losses? Was there new information or recommendations from staff as to how to characterize losses which factored into the grant of these or the approval of these permits?
Well, the department's position, as the evidence in the record does show, has always been that these system losses were reasonable. that is something that the CWORM found in its 2018 decision when it examined that issue at length.
So,
Sierra Club's, oh, I'm sorry.
no, go ahead.
Sierra Club's, one of its contentions at trial was its displeasure with the fact that the term waste had not been defined previously. So we argued throughout the trial that reasonable system losses do not constitute waste. And then staff defined the term waste in its subsequent staff submittal.
Which was after that trial.
Correct.
Which is what was taken into account in this matter, correct?
Yes, but I would say that the subject matter, the definition of waste was consistent with the board's and the department's, position throughout.
Wait, I mean, didn't CWORM have concerns? I mean, didn't CWORM say that system losses exceeded 20% and that didn't comport with best practices?
Well, I think we're getting a little bit lost in the weeds here because the bigger picture is that it's under CWORM's exclusive jurisdiction to address those kinds of issues, not the board. The board had a duty to dispose of public lands in a manner that served the interests
But
of
I
the
guess,
state.
okay, I understand the divide you're making, but isn't that information before the board that is important, especially with the renewed or different definition of water waste? I mean, it seems that that would be, information that would be needed to, turn it over, shake it up, see what it really means, to inform the board. I mean, I know you made 27 new conditions and some of them address Sierra Club's concerns, but when you look at that water waste issues, and it's not just the CWORM that I'm talking about, but some of the other things that were brought out, it seems that's sort of significant new evidence to take a look at.
Well, courts have generally recognized that cross-examination of scientific facts is often an exercise in futility.
Really?
Yes. The Coastal v. Pacific.
Cross-examining experts about scientific facts is an exercise in futility?
That is a quotation that comes from the.
I suppose it depends on the skills of the cross-examiner.
Well, and it also depends
I'm trying to understand what I did for all those years in private practice, but I guess.
It also depends on whether there are scientific facts that the cross-examiner is using to cross-examine that information with.
I mean, it can be frustrating. It can be slow. There can be ambiguity. There can be different points of view. But in the end, that's exactly why you have the test of cross-examination, so the finder of fact can come to determination. Right? If anything, that cuts in favor of a contested case hearing.
Well, the U.S. Supreme Court in Coastal v. Pacific Legal Foundation looked at contentions regarding EPA permits for pollution discharge. And they found that there is no material issue of fact where one course had a greater adverse effect than the other course, because that is the type of balancing that's generally left up to the experts, and the agency is the entity with the vested expertise. And moving on to the burden. The burden of duplicative proceedings outweighed any marginal benefits to Sierra Club in this situation. First, they had recently had a trial and could participate in public meetings.
I'm sorry, can I ask you, Judge Crabtree sat through the trial, and he was also the same judge that evaluated the public hearing. And he came to the conclusion that there was actually new evidence, and that's, I believe, how he characterized it. Wasn't he in the best position to judge what would be considered new evidence, given the fact that he presided over the trial and reviewed the public hearing, where there was something like 13,000 pages of documents?
That's a good question. However, in reversing a decision to deny the request for a contested case hearing, the court was necessarily determining that the record was insufficient without facts that could be fleshed out in a Chapter 91 contested case hearing. So it cannot then turn around and make substantive findings in order to modify RPs without...
But there were no findings.
Well, it determined that a certain number of MGD was reasonable under the circumstances. That was a finding that it did not have a full record to make that decision on. As this court has recognized, when a court is sitting in an appellate capacity, it does not engage in fact-finding and weighing of the evidence. Here, the question before the court was really whether additional procedures were actually required to protect the asserted interests of the Sierra Club in this situation.
Would you agree that our natural water resources are probably one of the highest priority resources that require protection?
They're absolutely a high priority resource. However, if we go back to the Flores case, the interest at issue in that case was Native Hawaiian traditional customary practices on Mauna Kea, which is also a very important interest. However, as the Flores court, this court made clear, that is not the end of the inquiry. The inquiry then goes on to balance those Sandy Beach factors. And here, Sierra Club had a full and fair opportunity to vet all of its concerns regarding the revocable permits. And
Well, I guess it would be how you define vet, because that's where the push seems to be in this case.
sure, however, again, I would go back to the fact that cross-examination is not a required component of due process. Notice and an opportunity to be heard, which is evaluated on a case-by-case basis. And here we have a very clear record establishing that Sierra Club was not entitled to additional process to protect any interest it might have had.
Let me ask one more question before you pass the baton. We've talked about the diversion from the Maui streams going back to 2000 without a contested case hearing at all. When you're looking at what determines, what procedures are necessary to satisfy Sierra Club's due process rights, is it appropriate to look at, the 1-year RP in the context of 20 years of annual RPs?
Well, I think the larger context of this entire dispute we could talk for hours on. However, what was presented to the board at the time it was making its decision is what an appellate court needs to evaluate. And what the board was presented with was Sierra Club had already had full process through a trial to explore many of those issues. And it had an opportunity in the Sunshine meeting. It did not show a risk of erroneous deprivation that would outweigh the burdens to government. It did not show that it could add meaningful value to the protection of its interests through an additional contested case hearing.
You can wrap up. If you have any final thoughts for the court, please wrap
Sure.
up your presentation.
So, in conclusion, the environmental court exceeded its appellate jurisdiction by modifying the permits without finding board error or abuse of discretion. It made findings on an undeveloped record, and it substituted the court's judgment for that of the agency. We respectfully request that this court affirm the ICA's conclusion that both the board's denial of Sierra Club's contested case hearing petition was proper, and that the environmental court erred in determining otherwise and by modifying the RPs itself.
All right, thank you very much, Ms. Goldman. We'll hear from Ms. Akagi at this time.
Thank you, Your Honors. I want to jump right into the contested case hearing issue. This case falls squarely within the precedent set by Flores. But here, there is an even lower risk of erroneous deprivation because Sierra Club, less than 2 months prior to the BLNR subject decision, had a full trial, along with all the accompanying procedural protections. They had an opportunity on top of that to address the board prior to and at the November 13th meeting. And third, unlike the decision that was at issue in Flores, which was a long-term disposition, the construction of a 30-meter telescope, here this is a short-term disposition, 1-year revocable permits terminable upon 30 days and subject to mandatory annual review. So Justice Edens had asked about should we consider this in the context of larger decisions, but as this court explained in Carmichael, the unique what makes the RPs temporary is the fact that they need to be considered every year. So you have other decisions where, for example, in Flores, Mr. Flores would not have had any other opportunity to address any concerns that he may have had regarding the construction of the 30-meter telescope. Whereas here, Sierra Club has an opportunity every single year to raise any concerns or issues that it may have before the board, and the board needs to make another separate decision each year whether or not to continue these revocable
But then that's
permits.
20 years of public hearings as opposed to an actual adversarial process, which in Mauna Kea, we recognize the value of a rigorous adversarial process, and it just never happened over 20 years. It's like a 20-year lease without any real challenge.
Well, it's incorrect to say that there were no adversarial proceedings with respect to the diversion of this water. So the Water Commission did hold a contested case hearing on the diversion of water from
Talking about
27.
BLNR.
I understand that, but I just want to put in context that there have been adversarial proceedings. BLNR did convene.
BLNR is the authority that's granting the permits, right?
It is. So BLNR did convene a contested case hearing in response to a request from Namoku. So despite the characterization of Sierra Club that there was never a contested case hearing, there was. But the request was both for the long-term lease and the revocable permits. There were decisions made in that proceeding. There was an evidentiary hearing held to determine whether additional water should be dispersed to certain streams. So there was consideration by the BLNR, among other agencies, as to these specific diversions.
What year was that?
I believe it was around 2008, 2007, somewhere around there. The contested case hearing was convened in 2001.
About 19 years prior.
My math is not great. I will take your word at it. The issue, so Flores doesn't require the amount of overlap that the Sierra Club suggests. In Flores, the relevant consideration was what is the impact on the petitioner's asserted interests. They explained that in the case of Mr. Flores, the potential impact of the sublease on his asserted interests appeared to overlap entirely with the potential impact of the CDUP.
I don't disagree with that overlap part, because it becomes duplicative, but can't you have a contested case hearing and just narrow the issues down and eliminate the accumulation of or duplication of evidence or things that may have happened and been vetted at the trial versus brand new evidence, brand new conditions, brand new staff reports?
It certainly is possible. The question, though, is not whether it's possible, it's whether it's necessary or required under due process. So in this context, you have to look at the totality of circumstances. They just had a full trial on these same streams, same issues, all of this evidence that is supposedly new and material addresses the same issues that were addressed in the trial. On top of that—
Right, but they're only arguing about the new evidence, things that came up post. That's what they're saying they didn't really get a good shot at.
I understand, but it relates to the same issues. And the impact
It can be the same issue, but it's new evidence. And that's what they're saying. We didn't get a chance to challenge that. It came up after the trial. And then it's being considered, or it should have been considered in depth for this public hearing, and they didn't get a chance at doing that.
Right,
That
but so—
seems to be their argument.
I understand. The question, though, is if you look at the totality of circumstances, was this information so different and so material than that what was considered in front of the trial to
It
require—
seemed to be for Judge Crabtree.
I'm sorry?
It seemed to be for Judge Crabtree. He said it was sufficient. They should have had a contested case hearing. It was that significant for the judge.
Well, I don't believe that Judge Crabtree analyzed this in the right context. The question is not to look at the evidence in a vacuum. You have to consider
He presided over the trial. It wasn't in a vacuum. He had both perspectives.
I understand, but I believe that Judge Crabtree's analysis was limited to whether or not this information was present or not present at the trial.
What about the system losses? What about the new recommendation or rule to exclude system losses from waste? Wasn't that new? Wasn't that significant?
The issue of system losses was thoroughly discussed in the August 2020 trial. What happened during the trials is that the Sierra Club argued that system losses were per se waste. So BLNR was attempting to clarify that not all system losses are per se waste. That was the point. And the question is this material—
Was it not all, or was it going to be to exclude system losses altogether from the definition of waste?
I think they were saying that it's not per se waste. The question is this information so radically new and different that less than 2 months after we have completed a trial, we need to have another trial-like proceeding to address a decision on a 1-year revocable terminable upon 30 days notice that is subject to mandatory annual review?
I'm sorry, I'm kind of like harping on this, but the new issue of defining waste to expressly include system losses and evaporation. Isn't that something that deserved another look?
There was another look given to it at the public meeting. So Sierra Club had a full
At the public
opportunity.
meeting, but no expert testimony, no cross-examination as to what steps BLNR might be able to, conditions BLNR might be able to impose to reduce system losses and or evaporation.
No, but that also was not material to the impact on Sierra Club's interest. Sierra Club submitted the exact same declarations that were submitted in the trial to support its written petition for a contested case hearing, thereby conceding that the impact on their members' interests were exactly the same. On top of that,
Wait a minute. Sometimes at trial things come up, right? That's the issue. When you have contested case hearings and you have experts testifying and you have cross-examination, that's when you're able to, and I respectfully disagree that cross-examination of expert witnesses is a waste of time. I think a lot of things are developed through cross-examination. And I also disagree that BLNR plays no part in imposing conditions possibly to reduce or eliminate system losses and or evaporation. Seaworm's exclusive jurisdiction is to set the amount of water that should be flowing. But BLNR, as the trustee of the public trust resources, also has an obligation to try to save our water as much as possible.
understood. But the decision that was before the court in the trial was to allow the diversion of up to 45 MGD of water. The decision before the board at this 2021 meeting was to allow the diversion up to 45 MGD of water. So Sierra Club already had an opportunity to address how the diversion of up to 45 MGDs of water would impact its interests. That did not change with the BLNR's decision at the 2021 meeting.
But then you have conflicting statements being made and no one's really able to challenge the basis of those statements. I mean, isn't that the real value of cross-examining witnesses that are giving this information?
I think
Otherwise,
that
people are just saying whatever they want to say. I mean, I've been to those public hearings and people come up and say all kinds of things. Whether it's true or not, no one really gets to challenge it.
Yes, Your Honor. And the question is not whether or not people can make statements or there needs to be cross-examination. It's when it's less than 2 months after you just had a trial and you're considering a decision that does not materially change the impact to Sierra Club's interest on a short-term revocable permit that's going to come up for review the following year, is it necessary to convene another trial-like proceeding in order to protect any due process interest that there may
But don't
be?
stream and water conditions change? To me, this is really different from Flores because water conditions change depending on drought conditions, etc. So why shouldn't this be something that's carefully looked at every year?
And it should be. Just the question is, in less than 2 months after you've had a trial, is it necessary to convene a trial-like proceeding on a short-term disposition?
What period of time would then make it necessary in your position?
I don't think that we can draw a bright line because it depends on the entire facts and circumstances. How have conditions changed, as Justice McKenna pointed out? How much time has passed? What other proceedings have been ongoing where the petitioner had an opportunity to address its concerns? So I don't think it's possible to say right now, 1 year, 2 years, 3 years would require another contested case hearing or another trial-like proceeding. What we're limited to is the facts of this case, where less than 2 months after there was a trial, there was another consideration for a short-term disposition. And I want to turn to the modification issue before my time runs out. On modification, even if a contested case hearing was required, the court still doesn't need to address the specific parameters of the environmental court's authority to modify, because no matter what it is, the environmental court would have needed to at least make a predicate finding of clear error to modify a factual determination made by BLNR. Specifically, in order to modify the cap, the environmental court would have had to make a determination that the BLNR's cap was clearly erroneous.
You're saying that the environmental court has to find clear error before it can modify the decision?
Yes, that's what this court...
91, that's based on 9114?
And this court's decision in Nakamine. So in the Nakamine case,
Was that
This-
an environmental court decision? I can't remember.
No, it was not. It
Well,
was
what about 604A2B? In any case in which it has jurisdiction, the environmental court shall exercise general equity powers as authorized by law. So
As au-
why wouldn't it have that power pursuant to its general equity powers?
it has the powers that are authorized by law, and those are, in this case, it's the powers authorized by 91-14. So this court explained in the Nakamine case that although the circuit court has the power to modify agency decisions and can fashion a relief appropriately remedying the prejudice, exercise of that power requires specific findings by the court. In that case, in the case of Ms. Nakamine, the circuit court made no finding that the agency's determination that Ms. Nakamine's disability was not work-related was clearly erroneous, and thus the circuit court's remedy of reversing the agency's decision and ordering the benefits be conferred was not appropriate.
But
So
that was a reversal. This was not a reversal, right?
no, it was not a reverse. This was a reversal, but the language in 91-14G doesn't differentiate between when reversing and when modifying. It says the same thing with respect to reversal and modification. So under Nakamine, the court would have had to make a finding that the BLNR's cap was clearly erroneous if it was going to modify the cap, which it didn't. So-
What's your take on the 205A issue? Did the ICA get that right? That, well, not really, these are mountain streams. It doesn't really affect coastal zone management, or as Mr. Frankel suggests, it's part of a unified ecosystem and the waters flow to the ocean. Therefore, that should be a basis for a right to a constitutional right to a hearing.
As we explained in our briefing, we believe that the specific provisions that the Sierra Club had pointed to are not obligatory absent another provision within the CZMA. So for example, 205A-26, when you're talking about issuing a permit, requires a specific finding that the action is consistent with the policies and objectives of the CZMA. If the policies and objectives were automatically applicable, that would be superfluous. So we mentioned all of this in our briefing, but my time
I
is
know
up.
you did, but I'm asking you to argue, or I'm trying to give you the opportunity to argue it. So anything further on that point?
Not on that point.
All right.
Thank
Yeah,
you.
and you can wrap up then.
Okay.
Thank you.
As we argued that you cannot look at this in a vacuum. So you have to consider that there was a full trial less than 2 months prior to this board's decision on a short-term permit subject to mandatory annual review. As to modification, the court, whatever power it had to modify, could not do so unless there was a finding of clear error, which there's no dispute that there was no finding of clear error. Thank you.
Very well, thank you. All right, Mr. Frankel, your rebuttal.
Thank you. Ms. Goldman is right. That photograph there is not one of the 12, 13 streams, but in the Division of Aquatic Resources report, it describes the typicality of the diversions, and this is typical of the streams in East Maui. Many streams have been restored, but this case it particularly focuses on 12, the record says 13, streams that A&B has the right to take all the water from. The Division of Aquatic Resources in its report describes the 100% removal of water 70 to 80% of the time. That's in the record. The Water Commission says the same thing in its decision. Alexander Baldwin's own consultant in the draft EIS, which is in the record, says the same thing. Nothing in BLNR's 2020 decision or anything in the Water Commission's 2018 decision provides any protection for the 13 streams. The revocable permits allow all the base flow from these streams to be taken. The result is a picture like that with a stream with no water in it. That's what we're trying to address. That's what a contested case hearing is attempting to, what Sierra Club is attempting to do is protect these resources. And the board has the authority to protect these streams despite BLNR's position that it does not. 171-55 allows BLNR to impose conditions that are in the best interest of the state. This court has talked about the importance of streams. In Rapoon, for example, can it be said there's no public interest in a free-flowing stream for its own sake? That's part of the public interest, part of the best interest So the board has the authority under 171-55, the plain language, to impose conditions. The legislature has given the board that authority. And this court said the same thing in Carmichael, that BLNR's role as a public trustee of state resources, and that role imposes duties upon the board. The Water Commission itself recognized that authorizing how much water will be allowed to be diverted offstream once the in-stream flow standards are met is the purview of the Board of Land and Natural Resources. That's what we're asking the board to do. And in particular, a cap on how much water is taken allows water to stay in streams. The Board of Land and Natural Resources has talked about notice and opportunity to be heard. But they omit the key phrase, at a meaningful time and in a meaningful manner. And that meaningful manner, as all of you have mentioned, includes cross-examination. You can go all the way back to Mortensen, one of the first cases interpreting Chapter 91, a case that then attorney Ed Nakamura brought. And it describes how important cross-examination is in ascertaining the truth. In this case, the Environmental Court concluded that the Sierra Club's constitutional rights were violated. That is a substantial prejudice. That is the kind of finding that the Nakamini Court describes, that the procedural error here was not having a contested case hearing. Given this injury to constitutional rights, what could the court do? Modify the board's decision, attempt to preserve the status quo, and use the standard articulated by Fleming versus Napili to balance the equities. Look at everybody's interest and try to, in this case, preserve the status quo while a contested case hearing was held.
So in other words, the environmental court, perhaps it didn't use the words clearly erroneous, but it did find that there was an error not to have a contested case hearing because constitutional rights were being violated.
Exactly.
Sounds like clear error.
Exactly, Your Honor.
Mr. Frankel, what do you say to the concern that this might just be an endless parade of contested case hearings year after year after year that really are not accomplishing much, especially as that body of work grows?
Sure. My first response is when this court articulated in Pele Defense Fund, it was a geothermal case and held, it was Pele Defense Fund versus Puna Geothermal. And the court said, you have to have a contested case hearing on these permit applications. And the Department of Health freaked out. We're going to have all these. As far as I know, there's been no contested case hearing since that decision back in 1994. So other than the Sierra Club's contested case hearing on the Navy's application to operate the tanks at Red Hill, there's not a flood of litigation. If the Board of Land and Natural Resources properly fulfills its public trust duties, there's not going to be requests for contested case hearings. That's what this is all about. The board has abdicated its duties for decades, and the Sierra Club is asking the board to do what it needs to do. It needs to uphold the public trust. It needs to make sure that important questions are answered, that water is not wasted, whether using terms like system loss or wasted. If the water's taken out of the stream and not used, that's a problem. So if these issues are addressed, there won't be requests for contested case hearings. What is a stream without water? What is a beach without sand? That's the context of the Sierra Club's request for a contested case hearing and its attempt to protect public trust resources. Thank you.
Very well. Thank you, Mr. Frankel. Thank you to all our attorneys for your arguments today. The court will take this matter under advisement.
A ku iluna, please rise. Ua ho'o ku'u ia mai ne ke aha ho'o kolo kolo ki ke hanano o ka moko aina Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.